About, what, 2 minutes to 1?
Yeah, 5 minutes.
5 minutes.
Make it shorter. All right, Richard, you ready?
Yes.
All right. Well, I guess it's my turn to speak again, and I wanted to catch everybody up on the David Tinchiona case. And just as a quick reminder, he was employed in 2010 by an employment agency called Titan Workforce. Titan Workforce had a contract with a HR company from Tennessee. And the HR company from Tennessee agreed that they would provide workers' comp insurance and they would do all the payroll for the people that Titan Workforce had. And so in a situation like David, he was a laborer for Titan Workforce, and Titan Workforce would go out and find a job for him. The job that they found was building a hospital office building. And so Descor Construction is a large construction company in the Sacramento area. They built one of the auto dealerships out on I-5, and so they do large construction. And so they would call up Titan and say, hey, we need 2 laborers for tomorrow. Titan would then call David and send him out to the job site, and they would hand him a shovel and a broom, and he had to wear a hard hat, and he had to have boots on, and then he would work and do whatever the supervisors at the construction site said that he had to do. And then if any of the workers became injured, then HR Comp would have workers' comp insurance, and the construction company, Descor, wouldn't have to have insurance, wouldn't have to have workers' comp insurance. So that's why Descor liked to have these employment agencies, because it's send me workers and they don't have to worry about any of the taxes, they don't have to worry about any of the withholding, they don't have to worry about anything else. So the problem is that, and it's becoming a larger problem in the state of California, is that these employment companies like Titan, they're contracting with out-of-state HR people. The out-of-state HR people, the reason why they're out-of-state is because the states that they operate in, like Tennessee, Kentucky, Texas, Louisiana, don't have any laws that require them to have workers' comp insurance or to do the things that California requires employers to do. So they don't do them. And so Titan Workforce thought that they had workers' comp insurance and told Descor that they had workers' comp insurance, when in fact they didn't. So David is sent out to the job. And the first day, he's coming down off the ladder after taking some air conditioning filters out of an air conditioning duct. He slips off the ladder. When he hits the ground, he feels a twinge in his back. Now, David is 68 years old at the time. He had, 20 years ago, he had a lumbar discectomy fusion. And so he's been very healthy and working as a laborer, supplementing his Social Security by doing this labor. And just the numbers, just to give you an idea of how this works, Descor pays Titan $18 an hour for every hour that David works. So the Titan will send paperwork to Descor. The Descor supervisor would say, yep, he was here, and send it back to Titan. Titan would then bill Descor. Descor then pays HR Comp $18 an hour. HR Comp pays Titan about $5 an hour. They pay David about $5 an hour, withholding the other $5 approximately, and HR Comp keeps the rest. So every time, and just in a week's period, if you do the numbers, it's about $720 a week for a laborer to work a 40-hour week. The laborer gets $200 of that amount, and the rest of it gets divided up between Titan, HR Comp, and that's why they do that, is because they're making a hell of a lot of money.
So it doesn't even minimum wage?
They were telling David that they were paying him $10 an hour, but by the time he gets all the money taken out of his check, and Titan did some things like they would say, well, we gave you a shovel, we gave you a hard hat, and we gave you a broom, so we're going to charge you for that, and stuff like that. And so his $10 an hour shrinks down to about $5 an hour is what he takes on. Now David is willing to do this. David is not he had 11th grade education. one time in his life, he operated forklifts on in a warehouse, and that's how he ended up breaking his back. The brakes on the forklift back in 1980 something failed, and it went off the loading dock, and he had to jump for it, and when he did, it broke his back. So he had a surgery, but by 2010, when he's working for Titan, he's perfectly healthy and he's able to do things. And in fact, I got some of his write-ups. The Descor and some of the other employers thought that David did a great job, and they would ask for David. They wanted him because he was a little bit older. He was somebody that they could send out on the job, and he wasn't going to be screwing around or doing anything. He was responsible, and he would get the job done. So in this particular situation, David steps off the ladder, hurts his back. He feels a twinge. He goes and reports it. Then this July 4th is the next day, so he's got a day off. He comes back on the 5th, and again, late in the afternoon, he's rolling a dumpster full of sheetrock and dirt and crap out of the hospital building, and he's putting it in a 40-yard dumpster when he slips on the ramp and falls and screws up his leg, screws up his elbow, and he's in a lot of pain at that point in time. A co-employee sees him in the dumpster, and what are you doing? And another Titan co-employee, the guy that was sent to the job to work with David, what are you doing in the dumpster? And David says, I just fell, and I need to gather myself a little bit and rest for a second before I can go back to work. He actually didn't go back to work. So David then submits a work comp claim, and HR Comp is supposed to have work comp. They pretended that they had work comp, and they paid him temporary disability benefits, and they paid him $104 a week for about 8 months. But he had to go to the doctor, and he went to Urgent 7 was the doctor they required him to go to. And after a couple visits to Urgent 7, the doctors at Urgent 7 said, this is an urgent care clinic, you are more seriously injured, don't come back here anymore. And HR Comp paid the Urgent 7 clinic. And so then he went to Kaiser. He had no place else to go, and he wasn't a Kaiser member, but he knew somebody who was a Kaiser member. So we went in with this woman, and they took some x-rays, did an MRI, and said, yeah, if you sneezed, if something happens, you step off a curb, you could be paralyzed. They put him in an ambulance and drove him from one of the Kaiser Rosevilles to Kaiser Morris, where the next day they operated on his back. And thoracic spine surgery, $140,000 in medical bills. And when that bill hit HR Comp said, oh, never mind, we don't have workers' comp insurance. And they stopped paying, and everything was at a standstill. Nevertheless, they did hire an attorney to respond to David's work comp case. And the attorney took a deposition, and then called our office. We were representing David, and called our office and said, don't worry about a thing, you're going to get a check, David's going to get a check, we're going to pay all the medical bills, everything's going to be cool. And then a month later, they substituted out of the case, and they were gone. The temporary disability payments, $104 a month, that stopped. David's medical care, no longer paid by HR Comp, that all stopped. And so, because all that happened, we brought in Descor, because Descor was the supervisor on the job. If Titan Workforce doesn't have workers' comp, and HR Comp's not going to do it, then Descor is, so we joined them in the work comp case, and they came in screaming and kicking and not wanting to have anything to do with this. And I don't blame them from their perspective. They had a contract, and the other people dropped the ball. That's not David's fault, that's the other people's fault. So we also, because this all happened, finding out that Titan did not have HR Comp with workers' comp, we found that out about a month before the 2-year statute of limitations was going to go up. So we didn't know if Descor was going to step up or not, so we had to file a third-party case. So it's a Labor Code Section 3706 cause of action. 3706 says when there's no workers' comp insurance, you get to assume that there's workers' comp insurance, and under the workers' comp insurance system, and it's a no-fault type of situation. And this is, then we step into the work comp world, when you have a no-fault situation, this has been California law since 1910, it was too expensive for employers, and that's what they actually said. We can't have our employees who get hurt on the job suing us employees, employers. It'll put us all out of business. So they made a grand bargain, they call it. And the grand bargain was that if you're an employee, you're an AOE, COE, if you have injuries that arise out of your employment and your injuries are caused by your employment, then the employer must pay for the medical bills and must pay temporary disability and a death benefit if you die, and then a permanent disability benefit. That used to be, back in the old days, they had a vocational rehabilitation benefit that no longer exists. And so when David lost the work comp aspects of the case, they disappeared. We brought the 3706 case against Titan and Descor and started a long grind of litigation against in Superior Court. We also brought in Dignity Health because they own the hospital. And so Dignity Health made a motion to dismiss our third-party case, and they really had good basis to do that. However, I was able to defeat their motion for summary judgment to dismiss them out of the case, and then they paid us $7,000, basically, go away money. Then Descor, and the very first day that I saw the Descor attorney, I said, this thing's going to come down on you guys. Let's get together. There's no sense in spending a lot of money, doing a lot of discovery, wasting time. Let's just get this thing into a mediation and figure out what the case is about. And she said, no, you got the wrong people here. Go get HR Comp. And we did some research on HR Comp. They're a Tennessee company. HR Comp is a Tennessee company. And the person who owned HR Comp ended up going to prison. And so there's no pocket there. There's no viability in HR Comp. And but Descor's insurance company is a company by the name of Everest. And I don't know if you've had any contact with Everest, but so Everest was defending Descor in the third-party case. And when we joined Descor in the work comp case, they were defending Descor in the work comp court and fighting us every which way. So they were fighting themselves, basically, by fighting this case. And then they hired a third attorney, a third law firm out of LA to intervene in the case. And they said, if you get any money out of this case, we want it. And so I called up that attorney and I said, are you guys stupid? You know, you now have 3 attorneys representing the same entity in this case, and you're all fighting against each other. You know, what the heck are you guys doing? And so, in the meantime, we had the curse of Tinchier. He had Social Security $1,400 a month, but the guy had this back surgery for several months. He was on a walker. He now walks with a cane, but he can't go back to work as a laborer, and he can't supplement his income in that way. So he was couch surfing for a while. He lived with his daughter in Antigua for a while, and $1,400 a month wasn't enough to take care of all of his bills. So he ends up going up. He had a son in Oregon, and his son his girlfriend's parents had a shed on their property, and so he moved into the shed out in behind their house, and he had no running water. During the day, I actually stopped by there last summer, and if you were inside and you looked towards the ceiling, you could see daylight through the roof. So when it rains, and it rains in Oregon a little bit, the water came through, and so he had on just one side of the shed, he had all these buckets and coffee cans and things like that to collect water. He says, well, I have to move them out of the way when it's sunny so I can walk through here, but when it starts raining, I want to get these buckets and things out to catch all the water so that I can throw it out. And once a week he would take his laundry. There was a campground on the other side of the freeway, and he would take his laundry over and take a shower because he had no running water where he was living. Things are really looking up for David now, because Descor and Titan, HR Comp, Dignity have to pay anything since that initial temporary disability of $104 a month, and that quit. And they provided no medical care for him in all this time. But his son went and bought him a travel trailer, and they hooked the travel trailer up to the people's house through a hose. So now he has running water, and that's a big improvement in his life. So the case is, I'm pushing the case to go to trial, and I got the intervener there, and I told the intervener, the Everest attorney who's standing there with the hand out, I said, this is going to cost you more than you're going to get, because you're going to bring all the experts. I'm not going to put on any experts. You know, if you're going to get all the money, and they legally, the statutes say they get the money that we get out of the recovery. So I said, I'm going to put my client up, and he's going to tell a story. It'll take a day maybe, you know, because we're going to make everybody cry in this place. And then you're going to bring the doctors. You're going to pay for the jury. You're going to pay for everything else in this case. And the message finally got through to him, and I think he was a partner in the firm, because about a week to 2 weeks later, they said, okay, let's mediate. Now, we had set up a mediation a year before, and they bailed out. They agreed to a mediation, and the last second, they pulled out. So another year has gone by. We have our mediation in December of 2016, December 20th. We have our mediation, and so we presented to them the value of the work comp case. And they said, we're never going to pay you more than $100,000 for this case. Well, when you look at in work comp, cases are rate out, and there's the AMA guides tell you what it is. And you know, virtually anybody can look at the whole person impairment. You look at the qualified medical examiner's report. Based on that report, you go to the AMA guides, and you can figure out what the case is worth. So we figure out the case is worth $105,000. You know, just on the PD basis. Plus he's got future medical, and they tell us they're not going to pay us more than $100,000. Well, the work comp judge has to approve it. And so we just said, well, you know, no judge is going to approve this. So we finally got him up after, and this was a grind of a whole day, working with Titan contributing some money, not very much, DesCorp kicking in some money. So, you know, DesCorp did pay some money on the third-party case, and Everest ended up paying the majority for the work comp case. And so on December 20th, we settled it for $180,000. My third-party case, where I've defended 3 motions for summary judgment, where they've done motions to dismiss our case. It takes me a week to respond to a motion for summary judgment. We dismissed our case because if he gets a penny in our third-party case, the workers' comp people get it. So it doesn't make sense for us to get a penny in our case. But I had to defeat and defend those motions for summary judgment in order to keep their feet to the fire and get the case settled. So that's December. And they said it's going to take about 30 days to get the workers' comp board to approve the settlement. So a month goes by, and I emailed everybody and said, where's our settlement? And another month went by, and they said, that's your responsibility. So I pushed the case, and we went to the court with a compromise and release. We had to go and get all the paperwork together and take it in, and the judge has to approve it. He has to approve the settlement, and we presented everything to him, and it's called a walkthrough, where you have all your papers in the case, and you show the judge, and the papers were about 3/4 of an inch, and the judge took one look at it, and he says, this is too much, I can't do this right now. There's too much business going on, too many things flying around the courtroom and the work comp court at the time. So he said, I'm going to take this under submission. A week later, he made a ruling, and this is about a month ago now. He made a ruling that he said, this is inadequate. I'm not going to grant this. Now, he agreed with he did the rating, and he came up with 108.5. We came up with 105, so we're real close there. But there's all sorts of future medical involved in this case that he says this is inadequate, and so he requested the defense to either come up with more money or respond. So the defense, of course, their response is that, well, this is a disputed case, and we are not agreeing that it's AOE COE. Now, that galls me. The work comp people in our firm say, oh yeah, they do that all the time. You know, don't get upset over this. But they had David submit to a qualified medical examiner, a doctor of their choice, basically, in 2014. And he said the case was AOE-COE. Ordinarily, that would be the only evidence that they need since January 1st of 2013. It's all one doctor, and that's it. They didn't, Everest didn't like that doctor, and they were not in the case at that time. So they said, we want a doctor. And so they got another doctor. And that doctor came back and said it was AOE-COE. And so then they hired a doctor in our third-party case, and the doctor said, oh, he got hurt in a couple days after this incident. He didn't get hurt on the construction site. And they paid that doctor $24,000 for that opinion. And and I know all this because Descor filed a memorandum of costs in our third-party case, wanting us to pay their doctor that $24,000. And so I had to fight that also. And the court granted my motion to strike their costs. But I found out how much money they paid that doctor for that opinion. But that evidence is not admissible in the work comp case at all. And then the employee, they also cited saying that the employee said that he didn't see him step off the ladder. So we're disputing that he stepped off the ladder. And so right now, David still hasn't received his money. We had a settlement. It was mediated. It took us all day to get it mediated. And the defense is still saying, we don't agree that it's AOE-COE. We don't agree that this is a work comp case. And I can't wait to get him into court. I started on the curse of David Tinchiera, the defense attorney for Titan. In the meantime, he died. Then Descor's second doctor, that they continued the case and got another QME doctor. He ended up getting very sick and left the state, and we're not sure if he's alive or dead yet. And so that's the curse of David Tinchiera, and I just tell the defense attorneys they better pay some money before somebody else something happens to them. So for Malika's sake, I also I'm doing a lot of learning about workers' comp now. And so one of the units that I had recently was on workers' compensation fraud. And this guy who's a law professor at a law school, I'm not even sure, I think Pepperdine or someplace like that, he lectures the state bar and other groups on workers' comp and workers' comp fraud. So he said that one of the things he says is that he goes to the insurance companies and he asks the adjusters 4 questions. Are you always honest? Are you mostly honest? Are you sometimes honest? Or are you never honest? He asks all the adjusters this. So the adjusters, nobody says they're never honest. Some of them say they're only sometimes honest. Most of them say they're mostly honest. And a few of them, very few, say that they are always honest. So that's the adjuster who's making the decision of what your case is going to be worth if you're an injured worker. Now, if you want to say that somebody is committing workers' comp fraud, Penal Code Section 550 is the code section, and it says that it's unlawful for anybody to present a statement in support of or in opposition to a work comp claim that's untrue. Okay, so if they say that they're only mostly, they're in violation of the Penal Code as it stands. Except that the case was taken up, and in fact, if you want to claim that there's been a fraudulent claim before the Work Comp Board, there's a form that you can go to the Department of Industrial Relations and get a form to fill out and say, I think there's been work comp fraud. It asks who the reporting party is and it asks who the victim is, but the victim can never be a company. I mean, the person who committed the fraud can never be a company. It can only be an individual. And so a case came down, and this is in 2006, where there was a lawsuit, and they alleged that the insurance company had committed fraud in their advertisements and in the way they handled their claims. And the court said, that this, that part of in opposition to, they don't mean that the insurance company or its adjusters who are in opposition, that doesn't mean that they can be found guilty, because claims adjusters do not support or oppose claims. They approve or deny claims. And so since they don't do these things of opposing or submitting, they only support, or they only approve or deny, then they can't be in violation. And there is no penal code section that covers the insurance companies when they deny things without any absolutely no reason. And so, and it's cases are legion that in situations where the insurance company, if you ask them for a benefit printout, they have to give you a benefit printout of everything they've paid in a case. So at the end of the case, we always get a benefit printout, and we can see where they've engaged investigators to do sub rosa investigation. We can see where they've hired doctors to do to write reports and things. Now, they will hire doctors to change the QME evaluation and never disclose those doctors because they obviously are higher than what our QME doctors or what the other side's QME doctors are. So there are laws here that are only construed against injured workers, not against the insurance companies or the adjusters. So I'm out of time. Any questions?
Now, are you getting paid on David's case?
On the third-party case, I'm getting nothing.
Right.
On the work comp case, we get 15% of the PD. So he's going to get about $140,000. And we have some costs that we've taken out of our pocket to make the case go forward. So you know, in that situation, we presented this to the judge too. We're not taking a fee. Normally we take a third. We waive that fee completely. And we're getting about $5,000 in costs that we've taken out of our pocket to make the case go forward. And then we're getting 15%, which is the standard workers' compensation. So
For years of work.
for
years of work.
yeah, for about 4 years of work.
I know.
And that's $140,000 for David. He's 72 now. You know, what's he going to do with that money? One of the things, his car doesn't work and he doesn't have a license for the car. And so he is going to, he needs a vehicle. And so he's,
You do my.
Let's just tell them a qualified financial advisor and come up with a plan.
yeah, yeah.
Generate some income off it, you know.
And maybe he could get out of the trailer. So anyway, I'm out of time.
Thank you.